There is a basic principle in law that a matter cannot be heard by any court if the same issue has already been decided in a previous suit between the same parties. And this principle is known as the principle of res judicata as defined under section 11 of Code of Civil Procedure. But even if there is some previous decided suit and your opponent proves in the court showing the evidence that there is a previously instituted suit and the matter has already been decided, still you can save your case from res judicata. How? Let us see in this video. Further, before starting the video, very important point, there is another provision in the Code of Civil Procedure, Order 7, Rule 11, which talks about rejection of plaint. I have made a video which you can see by clicking on the I button. So according to clause D of this Order 7 Rule 11 CPC, if the plaint is barred by any law, barred means prevented. If a plaint is barred or prevented by any other law, the plaint should be rejected. So I will tell you in this video, if the plaint is barred by res judicata, still how can you save your plaint from being rejected? So let us understand these nitty-gritties of law with the help of one of the latest Supreme Court ruling of 2023, Prem Kishore and others versus Brahm Prakash and others. So in this case, there was a landlord and a tenant. Land was given on rent to the tenant for residential purposes. Initially, the rent was duly paid, but after some time, there were arrears of rent, that is, the rent was not paid. So therefore, the landlord gave a demand notice to the tenant, but still the rent was not paid. So ultimately, an eviction suit was filed by the landlord against the tenant. So in response to this eviction petition, the tenant filed a written statement and submitted in the court that for eviction, first of all, the landlord has to prove the landlord-tenant relationship. If there is no landlord-tenant relationship, there can be no eviction. And as per the tenant, he is the real owner of the land. So now the burden of proof is on the landlord to prove that he is the rightful owner of the land and the person against whom he wants eviction is the tenant. But the fact was that multiple opportunities was given to the landlord to prove his case, to show some evidence, to show that there is some relation of landlord-tenant, but the landlord did not appear in the case. He did not file any evidence. And because of this, the rent controller ultimately closed the right of filing the evidence by the landlord. And because there was no use to continue the case, so the rent controller ultimately dismissed the eviction petition. It is to be noted that after the dismissal, no appeal was filed by the owner. Now, this owner who has filed this eviction petition passed away. Now his legal heirs, that is his lawful successors, filed a fresh eviction petition under the same Delhi Rent Control Act. Now in response, the tenant submitted in the court that this issue has already been decided in the previously instituted eviction suit, which got dismissed by the rent controller. Now the same plea cannot be raised again and again. Therefore, the principle of res judicata will apply and the court cannot hear it, and the new eviction suit will be barred by res judicata. And at the same time, the tenant has also filed an application under Order 7 Rule 11 of the CPC for rejection of plaint. Because as per the tenant, because the plaint is barred by the law of res judicata, therefore plaint must be rejected. However, the rent controller did not accept the application of the tenant and did not reject the petition. So against this order of the rent controller, the tenant moved to High Court by filing a revision petition. The High Court accepted the plea of the tenant and ultimately rejected the eviction petition filed by the owners. And High Court said that because no appeal was made against the order of the rent controller earlier, therefore that order has already attained finality. So again and again on the same issue, a new suit cannot be filed. So against this order of High Court, the owner went to the Supreme Court claiming that they are the rightful owners and tenant is not the owner. Now the issue before the Supreme Court was whether the High Court was justified in rejecting the plaint by saying that it is barred by res judicata. This was the question before Supreme Court. Now Supreme Court held that if we read Order 7 Rule 11 Clause D very carefully, it states that there should be some statement in the plaint which shows that the plaint is barred by any law. But in this case, the eviction petition, the new eviction petition does not show any statement, does not mention any averment which shows that the plaint is barred by any law. So Supreme Court wants to say here that for the purpose of rejection of plaint, only the plaint can be seen. even if there is some previously instituted suit, that should be on record, that should be in front of the court. But at the time of deciding the rejection of plaint, the previously instituted suit is not on the record. The court cannot see anything outside the plaint. So if the owners have concealed this fact from the court that there was some previously instituted suit, they are liable for concealment of material fact. They are liable for suppression of material fact. But for the purpose of rejection of plaint, the previously instituted suit is not material as per the Supreme Court. Supreme Court added that it is the tenant who is saying that there was some previously instituted suit in the written statement. And High Court rejected the plaint based on the averments made in the written statement. Therefore, the High Court is wrong here, because High Court has only to see the plaint and not the other material in the written statement. So by deciding the first issue, the Supreme Court ultimately held even if a suit is barred by res judicata, still the plaint will not be get rejected on its basis, because the previous suit is not on the record. Now we have talked about that if the res judicata applies, then what will happen? But the question is whether in this case the eviction suit is barred by res judicata or not. That is, even if the tenant brings the evidence in front of the court that there was a previously instituted suit and it was decided on the same issue between the same parties, still the res judicata applies or not. Let us see what Supreme Court has decided. So the basic rule of res judicata is that the suit is said to be barred by, prevented by res judicata only if the previously instituted suit is decided on merits of the case, that is the facts of the case. And if the previously instituted suit is decided on the technical legal points and not on the facts, then the res judicata will not apply. So the issue before Supreme Court now is that whether the first eviction suit was dismissed on merits or on the legal points. So Supreme Court held that the High Court made a big mistake, because as per the High Court, the order of the rent controller in the first eviction suit was based on merits. Because as per High Court, what cannot be seen does not exist. जो चीज नहीं दिखती वो चीज नहीं होती, ऐसा कहना था हाई कोर्ट का. So because the landlord did not file the evidence, therefore as per the High Court it is assumed that there is no evidence. So because there is no evidence, the court has decided that there is no relationship of landlord and tenant. Therefore as per the High Court, the decision was based on the facts of the case, on the merits. And because it was based on merits, the res judicata will apply. But Supreme Court ultimately held that for decision on merits, there should be some substantive merits before the court. But in this case, because the landlord failed to give any evidence to the rent controller, the rent controller just stopped the proceedings without going into the facts of the case. The ownership was not decided by the court. If the facts would have taken, the ownership would have been decided, that who is the owner and who is the tenant. But actually, because the evidence was not filed, therefore the proceedings were stopped, therefore the petition was dismissed. So such dismissal is based on legal technicality and not on the facts of the case. And because it is not based on the facts, that is the merits, therefore res judicata will not apply as per Supreme Court. So even if your opponent proves in the court that there was previously instituted suit, still it doesn't matter. As per Supreme Court, res judicata will only apply if the previously instituted suit is decided on the merits of the case. And if it is decided on the legal technicalities, then res judicata will not apply. So in the end, I would like you to know one important fact, that the eviction petition by the original owner was filed in the year 1996. Then it went to High Court, then Supreme Court. And by the time it was decided by the Supreme Court, the year is 2023. The landlord passed away. And now also it is not been finally decided. Only two specific issues have been decided, very narrow issues. Now it will go again in the court, and it is to be decided, yet to be decided, that who is the owner and whether the tenant will be evicted or not. So what are your viewpoints on such delays in a judicial system? I shall wait for your viewpoints in the comment box. We'll meet you in the next video. Thank you very much.